A senior advocate of Nigeria, Mohammed Ndarani, has advised the National Assembly to ensure that the current constitution review reflects the views of the people. Ndarani gave the advice during a press conference in Abuja. He noted that developments in the country justifies a complete overhaul and comprehensive amendment to the 1999 Constitution. He said that the current constitution has gone through 5 amendments and it is believed that it could be much better.
It has often been said that no constitution is entirely good or completely bad. It is believed that it all depends on the people who apply and implement the provisions. The truth, however, is that the Constitution has to be fundamentally solid and take into account the special characteristics of the entity for which the document is being drafted. If we must continue to tinker with the same document, however, developments in this country today justify the complete overhaul and comprehensive amendments to 1999 Constitution, which we must note was only made as an answer to a military decree. The importance of this movement cannot be overstated. Since 1999, successful amendment efforts have been suffered from a chronic lack of direction, elitist dominance, and meager outcomes.
He advised that the process must draw from the peculiarities of Nigeria, the demographics, ethnicity, economic structure, as well as the many other current realities.
There is therefore a great need for the National Assembly to make provision for a proper referendum prior to amendments to those critical areas of the Constitution. This is what will give the said Constitution or Act the touch of the people, imbibe it with much needed legitimacy, and bring the law closer to the people and vice versa. Considering that the zonal public hearings are already underway with plenary bill for October 2025, the voice of the people should be heard to ensure a greater relevancy and acceptability of the outcome. The world over constitutions are amended to respond to social, economic, cultural, and political changes. So the amendments processes must entail the mass participation of the people. It must be transparent, credible, and rigorous enough to ensure that it is done in the interest of the people and not to protect the personal interests of some individual. In many instances, amendments are seen as a means of protecting vested interest. Power blocks see the process as a political poker game rather than a democratic rearrangement to benefit all.
He questioned the rationale behind the removal of some submissions of the people by the National Assembly, especially the one calling for removal of the immunity clause.
We are talking about fighting corruptions at the highest places, and they are refusing to allow debate on the removal of the immunity clause for the governors and deputy governors. If we are talking about immunity clause, if we are talking about fighting corruptions in Nigeria, why should the senators, our senators and House of Reps members omit the inclusion of the removal of immunity clause from our constitution, which is a spinal cord of corruptions? How can you fight corruptions with immunity clause in the Nigerian constitution? It will be pretty difficult and very cumbersome, because it's not really easy to get an evidence to prosecute a matter well evidence has already been dissipated. We know what it takes to have what we call a solid evidence to arrive at what we call destination for a just determination of every individual matters in terms of civil or criminal matters. You can only sustain a criminal charge before the court when you have evidences. The review should result in a responsive, efficient constitution that will address structural, fundamental, and emerging issues within the Nigeria Federation. With the right constitution to guide Nigerian nation, this country has the wherewithal to be one of the leading nations on the earth.
Ndarani said he aligned himself with the Citizenship bill tabled by the Deputy Speaker of the House of Representatives, Benjamin Kalu. Kalu had proposed a bill to grant indigenous status to individuals who have resided in the state for 10 years or married a native.
I see it as a progressive move for national unity. Nigerian citizenship is primarily defined in Chapter 3 of the 1999 Constitution as amended. It outlined 3 ways to acquire citizenship. Nobody should be prevented from contesting for a position because his parents were not from a particular city, state, or local. Citizenship should take precedence over other mundane considerations. That means that you take a position based on citizenships in the state, not an indigenship, and there should be no discrimination. This citizenship provision is saying that Nigeria is one indivisible nation. It is Nigerian first before individual. The Constitution should have state citizenship. That is, you know where you come from. But once you have your citizenship, like for example, in the United Kingdom, nobody will ask you where you are from.